justice prevails. The government didn't prove their case. And the fact that, Karen Reed was not convicted is not a failure of the prosecution. Well, it's kind of, they shouldn't have brought a case like this. They should have done something different, honestly.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. Back in the saddle here with Robert and Nick, and the other Nick, who's not such a dick. But anyway, we are here reacting to Karen Reed and the verdict. I know this is a little bit late, but I was out of town, so. But I think it's interesting to kind of dissect this so you can kind of get a criminal lawyer's perspective on what it means. But before we get to that, this is brought to you by AskALawyer.com. AskALawyer.com is a very effective way to get legal advice for cheap. $45, and they have actual lawyers on standby. And I've actually had people email me say that they've used it, that they've gotten good advice. You can either, if you got a claim, you find out if you have an actual claim. What's the next step? Or they can tell you, hey, look, don't bother. Don't waste your time. That's valuable too. Or if you're doing your own research, they have an AI component. So it's trained in all the 50 states. I know my grandma thinks she's a lawyer in my basement, trying to do all kinds of things to me legally. The thing about it is she forgets it just as soon as she looks at it. So that's good. Anyway, if you go to AskALawyer.com, they're a valuable asset to the show. They're a good sponsor. And here's the other thing. They're the same people that brought you eForms and eSign. So it's quality folks. Okay. So let's just start with the verdict forms. This was a complicated case because she was charged with a whole host of stuff. She was charged with murder in the second degree, manslaughter, DWI, blah, blah, blah. And the defense raised concerns about the initial verdict slip, arguing that it was confusing due to the way it was presented to the jury as guilty and not guilty options for lesser included offenses. Let's just stop right there for a second. What's a lesser included offense? So if you have, say, criminal vehicular manslaughter or homicide that's caused, where alcohol is involved, well, the DWI, driving while intoxicated, would be a lesser included. Or let's say you have murder and assault, it would be a lesser included in that. So that's what a lesser included offense is. And the judge, here's the thing. I wasn't really impressed with this judge. I think the judge kind of had it out for the defense, honestly. It really, but they were from out of town. And so sometimes you get that. I, on the other hand, feel like when you're an out-of-town lawyer and you go into town, I always get treated better, it seems like. But she initially denied the motion to amend the slips, but later provided an amended version after the jurors raised questions. So one of the things that can happen while the jurors waiting or deliberating, and they can ask questions of the court. And usually the court will then send a copy of the question to the parties, and then they all meet or they confer and decide what we're going to tell the jury. The defense argued the original slips and structure should lead to errors and bias, particularly because it only had one not guilty box for the entire second charge, while multiple guilty options existed for the. In other words, it's showing a preference for guilty, and you can't have that. No, that's not good. Here's kind of a little clip of the defense, and the verdict forms. Sometimes in verdict forms, they have special interrogatories, in other words, questions. A case can be won or lost based on the instructions and based upon the verdict forms. So these things are argued in court outside the presence of the jury.
Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, and that you not suffer any person to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse them, to charge they verdict, except by further order of the court, so help you God? Simply because.
So what they're doing there is they are swearing in the deputy, and the deputy has to swear that he'll protect the jury, and because you can't let anybody back in there to talk to the jury while they're deliberating.
Because you weren't in the room. Thank you.
And let me tell you, this is a very tense moment. Now, this is the moment where, all the evidence is in, the final arguments have been given, and now the jury gets the verdict forms and they're about to go deliberate. And, as a lawyer, it's just like, okay, there's a relief that the case is over in terms of your work is now done, because it's grueling to go through a trial. I don't remember how many weeks was this, guys? Yeah, it's like a 2-month trial. That's a long, long trial. So if it's just this is a relief that you're done. However, there's this anxiety that you did a good job,
So, Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that.
Is this being done in front of the jury? So when you argue jury instructions and the verdict forms, this is not being done in presence of the jury. Even though you see all these people around that look like a jury, it's probably press and just, bystanders.
7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asked.
For every guilty, there should be a not guilty. It's just the way it should be.
Asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. Okay. We really ran into the same issue last time. I think what complicates it is the fact that there are 2 theories for 2 of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So okay. We would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti?
How about it's just fucking fair? I hate it when judges do that on something that seems so simple. Do you have any case law to support the notion that it's hearsay? The rule itself.
I have not found any. I've looked.
There's not a lot of case law out there this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean
so that's
just because it hasn't been found to be inaccurate yet doesn't mean that it's not inaccurate now. Because maybe it's a matter of first impression. Nobody's ever done it this way.
That's fine. So your rights are reserved. Does that help you?
Right, well, all we can do.
See what I mean? She's kind of got a snarky attitude towards the defense.
Okay. Okay.
Judge, the last couple.
If you find authority for that, let me know.
Will do.
Okay.
The last couple of things, judges, that we were provided with a clean computer laptop. Thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's.
So when the jury goes back to deliberate, they just started doing this in a lot of cases. So they get a laptop that doesn't have anything on it, doesn't have internet capability, but it has the ability to play the exhibits and to view all the exhibits that were in the trial, and which is really nice because if they want to watch the video, they can do it. Back in the day. Not that long ago, actually. It used to be, if they have a question, we'd like to see the video. You'd have to play the whole video with everybody assembled into the courtroom, and you don't have to do that now with the advent of this.
I think that's fine.
All right, so we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
all
you.
right, thank you.
All rise for the court, please.
So that just gives you a little flavor of what they're doing. Now, the moment of truth. When you sit there and you are taking a verdict, you know, first of all, how long do they deliberate? I recently had a case where the jury deliberated for 5 days, and it was the longest deliberation in my life. And every day that goes by, you're like, what the hell? You know, is a long verdict a defense verdict? Is a long verdict a prosecution verdict? Is a quick verdict a defense? There's no fucking rhyme or reason to these things. But you know, if it's a long verdict, if they're taking a long time to decide something, you got somebody on your side, usually. Let's take the verdict. Now, apparently it was 22 hours over 4 days. That's a long time.
Deliberating jurors remain standing. Defendant remains standing. All other parties may be seated.
Your Honor,
Fuck, your hands are just sweaty. I guarantee you, everybody's, you know, heart is pumping. Oh, it's just
the
amazing.
record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict? Yes. Thank you. May I see the papers? Mr.
Let me see the
Foreman,
papers.
The verdict has been
The
placed in
papers.
this envelope and have they been in your presence ever since?
I'm sure this judge, you know, I have a buddy of mine that's trying a case right now, and the judge just fucking hates the case. Just hates the case. And so anything that she can rule for the other side, you know, she just is like sticking it to him every time he turns around. And this judge, you can tell, did not, I mean, I think she tried to get this case. My understanding is she tried to keep the case, and that's how she wound up with it. But she is not liking the defense. So when she sees this verdict, I'm sure she was like, she's poker face right now.
Mr.
Oh, look
Foreman,
at that.
on
Maybe not
number,
so much.
2282CR117001, murder in the second degree. What say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree? Yes. Thank you. 002. What say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of.
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
003. What say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman?
Yes.
So say you all? Yes. Jurors, hearken your verdict as the court
You hear that crowd outside.
records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise.
So, acquitted of everything except for driving drunk. Over 0.08. I don't know how they got over 0.08. Was she ever tested? I don't remember if she was ever tested or not. And you have to be tested within 2 hours, generally speaking. So not guilty of second-degree murder, not guilty of manslaughter, and not guilty of leaving the scene of an accident resulting in death, but guilty of operating under the influence of alcohol, an OUI in Massachusetts or DUI, which is a misdemeanor. A misdemeanor. All that for a fucking misdemeanor. Dude, you should have negotiated something on that case. But they might not have taken anything. Juror number 12 spoke out. She said there were holes in the investigation, but she stopped short of saying that she believes someone else killed O'Keefe or that there was a police cover-up. This is what her statement was. I'm not there to say the defense story was right or wrong. Do you know what I'm saying? Because there could have been other circumstances that happened. I think there were things that we saw, things that we heard, the evidence that it could have fit that scenario. So again, the whole thing, there's doubt. So think about that. It's not that they didn't the defense proved her innocent. It's that the government didn't prove their case. Juror number 4 said, we did a lot of review of the tapes. It seemed to me that in the video of the car after the alleged incident happened, we could see the tail light lit up red where it shouldn't have been red. Interesting. I don't believe that the SUV collided with John O'Keefe. So, I mean, think about that. I mean, sometimes jurors will pick up on stuff and see stuff that you didn't know they were going to pick up on. And so here's juror number 11 giving her little statement.
How did your opinion of Karen Reed change throughout the trial?
At first, I thought her demeanor in court was a little bit too calm and composed for someone who was being charged for murder, especially for a loved one.
Do you see how they pick up on your interactions and what you're doing? I mean, here's the thing. A little too calm. This is her second time through. So they've already been through this. But jurors will look at you and judge you. I mean, and that's not even really evidence. It's just where you are in court.
But I learned how to admire, actually, that behavior. She was very participative on her own defense and helping each other and calm. I think her confidence was because she knew she wasn't guilty. And that helps me to change this prejudgment I have of her.
So you changed from thinking she was guilty to thinking not guilty?
Not just because of her behavior, of course, because of the whole trial itself and the evidence presented to us. Had too many holes and we couldn't.
This kind of stuff is invaluable. I've had a case where another trial happened before our trial, and we were able to talk to a juror that I knew actually quite well. And it was really helpful to see what worked and what didn't work.
Connect taillights to John O'Keefe injuries. We felt that was something else that could have pushed him to hit his head so hard that he had a skull fracture. And we definitely believe that if he was hit by a car at 24 miles per hour, we would find more injuries on his body.
Now, Paola, I know you work.
That's the problem I had with the whole case. He had no other real injuries. He had what looked like dog bite marks on his arm, right? He had a skull injury, like he fell back on his head, and he had some facial injuries. But he didn't have it. Like if you're going to run over somebody, you would have some broken bones somewhere else, wouldn't you?
You work as an attorney in Brazil as well, and you've presented cases. Which side really solidified your position, the defense or the prosecution?
I honestly pay more attention in the prosecution witnesses and the case they presented because I needed to see what they have to prove me that she was guilty. And of course, when the defense started bringing their witnesses, I already kind of had my mindset that Karen Reed wasn't guilty. So the defense witnesses just came in to.
That's interesting. You see what she said? She said, but when the defense started, I already had my mind made up that she was not guilty by the time the defense started bringing their witnesses in. And that is interesting because you can over-try a case, and all of a sudden if some of your witnesses go south, well, I kind of was leaning towards not guilty, but, they weren't able to answer these questions over here and they stumbled over here. You can over-try a case.
Top it off and make me more sure and certain that she wasn't responsible for John's death.
And what were the pieces of evidence presented from either side, really, that pushed you to find her not guilty or at least raise enough reasonable doubt?
Definitely the tail light. We had the opportunity to check the tail light from inside the deliberation room. So we had the broken tail light, the original one. We also had a new one to compare, and we had videos of Karen Reed getting out of the house in that morning at 5:07, 5 a.m. And we saw her car lighting. The red was way too strong and way more spread out as if her tail light wasn't broke that much.
So if it wasn't broken then, not guilty, right? Then how did it get broken? It had to get broken in police custody. And they have a saying for that. Methinks there's fuckery afoot.
Not much. The pieces that were missing were too much for us to be able to see the red light.
Now, the defense's allegations of a cover-up, I wonder if you think the jurors felt that could be true or if that held a lot of water for you.
It could be true. It could also not be true. The same way I can't charge Karen Reed with murder, I can't say there was a cover-up because I didn't see evidence for it. I saw holes and I saw a flop investigation, and I think the
danger with asserting that there's a police cover-up is that people want to believe police. You know, police are authoritative, you know, and you're in a fairly white community. And I'm just going to call it like I see it. And white people believe police, generally speaking, because, you know, they're not pulled over for being black. I mean, and that happens all the fucking time, especially, you know, in higher crime areas. If you are sitting there saying there's a police corruption and the jury's not coming with you, you could overtry your case.
Prosecution they worked what they had. The investigation was poorly from the beginning. No reports, no time, no videos that were missing. They could be covering for someone, of course, but also could be something else.
Like incompetence. And where did that trooper go, or where did that detective go? He got fired and he got rid of his dog. And there's just so many unanswered questions. But you can see how interesting it is on what the little things that the jurors pick up on, you know, and that taillight, I think, is huge. The foreman spoke out, and the foreman in the Karen Reed retrial told the Boston Herald, that there was no aha moment in the grueling case, that he said wasted taxpayers' money on paper-thin evidence that failed to bring any comfort to the victim's family. I mean, that is a blistering comment on the government's case. The unforgivable fact that investigators didn't swarm the house at the murder scene on 34 Fairview Road in Canton, Massachusetts, during the nor'easter was shoddy work and a blatant red flag. And that is exactly what the defense said, right? He also added, that's why the only guilty finding was drunken driving. If that body was on my front steps, I know my house would have been stormed. The juror, who is black and grew up in Jamaica Plain, said, the text from the trooper Proctor, bitch and whatever, also showed a serious bias, yet I had to put my personal opinion aside. It all seemed like a lot of wishy-washy privilege, the foreman said, you know, cop privilege. We had to look at the evidence, and a lot of it didn't make sense. And there was no meat, no aha moment. No one proved that there was a collision, even with all that jargon, and all the jurors agreed. So one of the things about reasonable doubt is it's defined, you know, it's proof beyond a reasonable doubt, and it's defined as the amount of care you would put in your most important affairs. And the reasonable doubt is the doubt that would cause one to hesitate, right? The foreman added that the jury's announcement of a verdict on Wednesday that was suddenly pulled back was over one male juror who had doubts. At lunch, I asked the jurors, are you okay? Do you think I can take back my vote, he asked. This is the one juror who had doubts. The other juror got a little nervous. The foreman said, but 20 minutes later, he said, okay, guilty of OUI. Operating under the influence. It was the only charge they agreed on and the only clear evidence. Without a doubt, the foreman added. We only went with what was put in front of us, he said. The panel of 7 women and 5 men. I'm still asking, where is the justice for John? And that's the thing that you have to really kind of look at, because they're not crime solvers. They're not out to find justice for John. Their job as a juror is to look at the evidence that's before them and decide guilty or not guilty. That's it. They're not crime stoppers. So these jurors making statements is interesting, because peering into the mind of a jury is a difficult thing to do because you don't really get to do it often. Another juror was speaking out after the verdict. She says she is disgusted by how much taxpayer money the Commonwealth has poured into the case and how O'Keefe's family is still looking for justice. And sometimes they don't have it. Guess what? If you don't have it, you don't fucking bring it. Walpole resident Paula Prado, we just watched her, said she feels deeply for the former BPD officer's family. It is not our fault that they didn't find out who killed John O'Keefe, Prado said in an interview with Howie Carr Show on Friday. The Commonwealth and the investigation, they couldn't prove that it was Karen Reed. For us, we had enough reasonable doubt that it wasn't her, and we couldn't convict her of anything. I really hope the O'Keefes can find who actually killed John O'Keefe, she added, and the DA, Michael Morrissey, reopens the case. And things keep going from there. I will be following. I will be watching closely. It broke my heart to see that family in court that day. And that's powerful. That's powerful stuff when a jury, is confronted by a family because they're innocent, right? They just want justice for their loved one, although it won't bring it back. So a little bit on the dog bite theory. Scratches on O'Keefe's arm, Prado said, did not appear to come from Reed's broken taillight, but rather from a dog, aligning with the defense theory about Albert's German Shepherd named Chloe being involved in his death, which I thought that all along. If you saw those marks, something happened inside the house, Prado said. What is? I don't know. I don't understand why the Alberts didn't come out, why the dog didn't bark at all. There were those holes that we can't fill in. And that's reasonable doubt right there. The Alberts and the key prosecution witnesses, most of whom were not called to the stand in the retrial but testified in the first trial, said they did not see O'Keefe enter the home that early morning. But everybody's drunk, and it's a house full of people. So what about the FBI? Judge Beverly Cannon, or whatever her name is, barred the prosecution and defense from directly referencing the federal probe into the investigation, which has since ended. Prado said she realized early on that the FBI had been involved, but it wasn't something that we took into consideration during deliberations, which is good. Prado said that her thoughts about Benjamin Brennan changed throughout the trial and that she can't judge him as a lawyer because the case was awful, full of holes. She added that she felt the judge, despite being very nice, gave too much protection to the prosecution with numerous objections during key defense witnesses. That's interesting. So she took a shot at Boston police officer Kelly Deaver, who was a member of the Canton Police Department at the time of the O'Keefe's death. Defense attorney Alan Jackson questioned Deaver on initially telling the feds that she saw Brian Higgins and then Canton Police Chief Kenneth Berkowitz enter the police department garage and spend a wildly long time with Reed's SUV. That's not for the cops to do that. It is for a criminologist to do that. So if they're spending a lot of time with this vehicle without documenting what they're doing, that's a real issue. This would give credence to the defense theory that police meddled with evidence, including busted taillight, whose pieces were later found at the crime scene. Deaver later recanted the statement as a false memory after being shown a timeline of events that proved it wasn't possible. Prado called Deaver not believable at all. That's the kind of shit that you want as a defense lawyer. It was uncomfortable to watch her behavior because she is an officer after all, and she is among us, and she carries a gun. She was not reliable and scary to know she's around holding a weapon. Could you have a more blistering comment from a juror about your job? So now the McCabe family interview, Albert and McCabe family interview. Let's see, this is a little note here from Robert, or Nick, one of the two. While slightly sensational, this video provides a good breakdown of the interview and implications of what they say during. All right, let's just see. I haven't seen this, so this is a little bit of cold reaction here.
The criminal justice system has let us down at every turn, and yesterday was the final letdown. And that's why we're here.
The Alberts and McCabes are here because the criminal justice system has let them down, despite being among the most well-connected. Bullshit. Justice prevails.
You know, the government didn't prove their case. And the fact that, you know, Karen Reed was not convicted is not a failure of the prosecution. Well, it's kind of, they shouldn't have brought a case like this. They should have done something different, honestly. But you know, the family is not a victim here. Well, they are a victim, but it's difficult when you hear them talk like this. They just got the wrong person, or they didn't have the evidence.
Connected law enforcement families in Massachusetts. In reality, they've benefited from extraordinary protection, including the district attorney himself violating his own code of ethics to personally vouch for their credibility while insinuating Reed murdered John O'Keefe in an attempt to taint the jury pool, all while enjoying the privileged status of witness for the past 3 years, a designation that's granted them a direct line to Michael Morrissey, access to the county's legal resources as if they were their own, and the ability to direct the local police force like a personal security detail.
Canton Police Officer Nick's recorded line.
Hi, Officer Nix. This is Attorney Ken Mello. I believe I just spoke with your sergeant there.
How can I help you?
Hi, Sergeant Ken Mello again.
No problem.
Do me a favor. Take a look at Chapter 268, Section 13A.
So it looked up. So what do you want? What are you thinking of doing?
I'm looking at that statute and saying they're across the street. They're certainly near Albert's place.
All right.
He's a witness, and they're certainly there for purposes of influencing or whatever else the statute states.
Okay.
They're not there for any other reason.
All right.
So basically, they're trying to taint the jury. And if you look at this picture over here, there's a concrete edge of the garage, which I don't know. Did that come out?
Yeah, it's in the video too. But yeah, that's out.
Is that his blood?
No, that's red. We think that's red paint, basically, that they used. The theory is that that's paint. And one of that they covered up the blood with, basically.
Why wouldn't you go into the home? Why you know, I mean, why would you just take all these cops' words for it? Because it's cop privilege.
So it's punishable by no more than a year in prison and a fine of no more than $5,000. So
correct. There's nobody left to stand up for us.
Think real long and hard before you're a witness in a case, because no one protects you.
Anyone
think long and hard. You know, when you go down to the park and you think about it long and hard, you get in your car, go home. You know, you ever been to Boston Harbor?
Anyone who knows anything about this case knows that they've been protected with the full power of state government. With Chris Albert being a town selectman, the chief of police literally reports to him. But there's something interesting about this picture. Where is Brian Higgins? If he's such close friends with Brian Albert, why isn't he here speaking in solidarity? Or at least sign off on the statement issued by the group following Reed's acquittal. According to nearly every other civilian Commonwealth witness, the negative attention they've received has brought them together. However, you get the sense that Brian Higgins and Brian Albert aren't quite as close as they once were. As far as we know, the last communication they had was a text message from Kevin Albert to Higgins, stating,
"Look, you went off the grid and Brian doesn't understand. You haven't called him. You haven't checked in on him since these subpoenas went out."
Yeah, there's the paint that's on the garage. And it just seems odd that, see, if you look at that spot, it seems odd that just, how did that paint get there? You know?
Went out. Everyone got a subpoena but you.
People turned this thing into a tailgate party, it looked like, some days. Board games, cornhole, cookout.
I can only imagine what it must feel like to have a national movement built around the exposure of your darkest secrets. But
well, and not only that, you know, to have your family member, you know, turn into a fucking circus. I mean, somebody died here, no question about it. How did that person die? I'm not convinced that Karen Reed ran him over. I certainly don't think that the taillight caused a collision with him. And it just seems like there's just, like the juror said, there's just too many unanswered questions.
That all came after John was murdered and has nothing to do with the evidence or facts of the case.
This is a guy that was murdered.
There's a guy unresponsive in the snow.
Tell them the guy never went in the house. Who was the guy that you were referring to? Does he have a name?
That would be John.
This group of family members framed Reed to cover up what really happened that night, ever since their lives becoming open season for endless conspiracy theories.
What they've done is they've dehumanized us. To the sense where we're not real people.
Yeah, I mean, it's worth it to come and yell at us.
Chris Albert's words fall flat after what you will see next. This clip appears to clearly capture him making vulgar, inappropriate remarks in front of Aiden's girlfriend. Listen closely. He's heard yelling something about banging her. A crude reference to Meredith, Aiden's partner.
I mean, we were just minding our, so we were just trying to mind our own business. So what? What did I do? He came up to us. We were walking in.
Shitty Lexus that you got paid for by fucking Karen. No, we didn't. He's a sack of fucking 2 seconds.
Justice for Peter Berger.
Up and down the sidewalk. 2 seconds.
You'll beat my face.
I wouldn't. I could.
You could. Right. You seem really intimidated. That park, that Lucky Lawson saw at 3 in the morning. Oh wait. Do you have a license, Chris? Do you get to keep your license after killing a man?
You don't want me in my car, right?
Do you? Oh, you need an escort, Chris? I'm not going to hurt you, Chris. I just want to ask you a few questions.
Oh, boy.
Oh, look who it is. Look who's here. Here she is.
You know what? I'm so sick of shit.
Oh, she stole my
It's a fucking circus. It's an absolute circus. So what's next for Karen Reed? Following her acquittal on a murder and manslaughter charges related to the death of her boyfriend, John O'Keefe, Karen Reed still faces a wrongful death civil lawsuit. But it's made a little more difficult, I think, here. One, you have to have a special duty to the person and then a breach of that duty. And so the civil suit, which alleges that Reed's reckless conduct led to O'Keefe's death, is ongoing, and that's the next chapter, I guess. Additionally, Reed was convicted of operating under the influence, which is a misdemeanor, and sentenced to 1 year of probation, so no jail, which is typical in a case like that. The standard of proof for a civil case is obviously a lot less. It's, just slightly more true than not true. But the main thing here is causation. Did she hit him or didn't she hit him? Or did she drop him off without him being drunk, and was there a duty for her to make sure he got to where he was supposed to go? So there's a bunch of different theories you could go there. So the question was raised in the civil case, is this an opportunity now for her to bring all the witnesses that they couldn't bring in the criminal trial? The standard is still the same. The standard is still the exact same for both the civil and criminal in terms of the rules of evidence and what is relevant and what isn't relevant and what's more prejudicial than probative. That's kind of the standard. But it's just, but it's less. You got to prove a fact in civil court by a preponderance of the evidence, slightly more true than not true, as opposed to beyond a reasonable doubt. When you lay all your cards on the table and you don't do things the way you're supposed to, but you get dug in, and that's what happens with these cases. A prosecutor will get dug in and invested, and they lose the forest for the trees. Then they cut corners, and then, like she said, like vouching for people and overlooking unethical behavior of a cop. And it's just like people's lives are at stake. Now, I'm not going to comment on his looks. I mean, he's not exactly a handsome guy. The jury has spoken, Morrissey said on the TV news outlet, and we try people in the court and not on the internet for a reason. The internet has no rules of evidence. Objection. The internet has no punishment for perjury, and the internet does not know all the facts. Well, I think we know a lot of the facts. He added the harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person. Blah, blah, blah. So that's our little take on the Karen Reed verdict. I know it's longer than you kind of expected. I should have told you at the outset to get a bottle of wine and some popcorn. We'll get back to our regular schedule. And so make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and make sure you go to askalawyer.com. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.
23-hour lockdown, police is at my god.